Hello everyone, welcome to my fabulous world. It's another day, another opportunity for us to interact, and today I've got Associate Professor Clement Marumoagae. But before I go on, remember to subscribe, remember to like, remember to share. It's important that you do that, and of course if you like what we're doing, press notifications so that you can get a notification every time we post an episode. But welcome. I'm at Vets, by the way, my home, right? I'm at Vets, and I'm so delighted to be here. I
told you you're going to struggle with that name.
Okay, Professor Marumoagae, how are you?
I'm fine, thanks, and you?
Good. You know, your bio online is amazing, right? I don't think there's anyone who writes their bio in Setswana, and then the second version is in English. In essence, it said to me, you started it in Setswana and then translated it in English. Am I right?
No, that is quite right. I mean, that's how I think, right? I think in my language, then I translate to the language of business, if you
really?
like, right? That is the only language that I can speak fluently, and I can express myself on, right? So it always takes precedence.
Great. I mean, I wish I could push you more on that, because how do you complete even up to a PhD? Thinking in your language, and of course language grows through use, and we know because of the limited use of Setswana, it hasn't grown as it should have, and so just fascinating. But maybe a little bit on that.
No, it's partly our fault, right?
Yeah,
the people who are using it.
Yeah.
Like for instance, I'll be speaking to you, but we'll be speaking in English, right? And we will be complaining that the language doesn't grow.
Yeah.
We need to take a conscious decision.
True.
That this is our pride, this is our heritage, and we ought to use it more often. And it's that there. If we start using it by speaking it, then we'll start writing on it, right?
Yeah.
And then the literature will grow.
True.
You know.
True that. Gone nkabe ntse re etsa podcast e ka Setswana, mara itse gore ba bantsi ba ka se ke ba ruta.
We'll be excluding a lot of people.
Wa utlwisisa. That's why we do it in English. So you are from Itsoseng?
I'm from Itsoseng. It's a township 30 kilometers the north of Lichtenberg. The so-called Ditsobot municipality that is all known for all the wrong things. That's where I come from.
Kana gona le tronko fale. Go Itsoseng or how fetsa go feta?
Not necessarily tronko per se. I mean, there is a holding cells, but I think maybe you are talking about the Roichron. It is just towards Mafikeng.
Okay.
And Mafikeng is about 40 km away from Itsoseng.
Okay, so it's after Itsoseng, between Itsoseng and Mafikeng.
Yes.
I mean, I just remember the signpost when I go to Mafikeng that at some stage I have to pass Roichron.
Yes.
And your specialization is family law.
No, I specialize in pension law.
Pension law?
Yes, I specialize in pension law, but I practice family law.
Family law?
Yes.
Okay, tell me what's pension law?
Pension law is the area of law where we deal with the finances of people who are retiring.
Okay.
Right, and trying to see as to how they can create wealth or create something that will lead them to be comfortable when they retire, right? So many disputes arise while they are saving to retire comfortably. So I deal with those kinds of disputes. Yes.
I mean, it's interesting. As you know, I'm a retiree, but I never had to speak to a pension lawyer. I spoke to a financial advisor.
Yes.
I don't know if I needed a pension lawyer, but my financial advisor knows money. And of course, he handled the same kind of concerns. How do we make sure that this money takes care of me until I'm 80?
No, well, it's not much about the investment side of it. It's when disputes arise, right? That a lawyer can actually be needed to try to assist you to make sure that you get what is due to you. Right. I mean, in most instances, you will need a finance person, not necessarily a lawyer, to advise you on the investment and all those kind of things, and the projections, how much you ought to have and ought to get at what point. You'll need a financial advisor for that. But in most instances, you find that the benefits that are due to you, you don't receive them as you ought to receive them, and that's where somebody like me will come in.
Okay. Now, that brings me to family law, because it seems like you also teach it. You said you practice family law.
I practice family law. I don't teach it.
You practice it.
I practice it, and I research on it.
Okay.
Yes.
When you say you practice it, what do you mean?
Oh, I'm also a practicing attorney.
Okay.
So in my practice, I do a lot of family law, a lot of pension law, So,
so if people want to get divorced, they come to you.
If that's what I specialize in. Yes.
That's what you specialize in.
Yes.
Okay. I want us, of course, to talk about the different marriage contracts and how do they interact with the marriage as we know it in the African culture. But perhaps before I go there, many people do not know, for example, that if they are married in community of property, they also have to share the pension.
Oh yes. Look,
if they get divorced,
I think there's only one marriage contract, which is the marriage itself. Okay. Right? It's a contract in itself.
Yeah.
Then you'll have those secondary contracts, like for instance your anti-nuptial contract. That really explains the regime within which you are actually getting married into, right? And you'll have, actually there are two kinds of marriages in South Africa. You have your marriage out of community of property and marriage in community of property.
Okay.
And there is a subspecies of marriage out of community of property, which is marriage out of community of property with an accrual system, right? So basically people will say there are three types of ways in which one can actually get married, right? Colloquially, yes, we can say that, but it's not quite accurate. Right, depends on how you look at it. So yes.
What's
so now,
accurate?
I beg your pardon?
What is accurate? When you
there
say
are two kinds of
marriages. There are only two.
Yes.
With accrual, it's just another.
It's just an add-on.
Subset.
It's just an add-on.
Okay.
But you are either married in community of property or out of community of property. Then out of community of property will need to provide that nuance, whether it's with accrual or without an accrual. Then it becomes important to know what your rights are, right? But apart from that, there are systems of marriages, right? You have your customary marriage, you have your civil marriage, and you have cultural and religious marriages, which are not necessarily recognized as valid marriages in South Africa.
Cultural and religious.
Cultural and religious, Muslim marriages, Hindu marriages, and all those. So there is no statutory regulation that deals specifically with them, as there is with customary marriages, because we have this customary recognition of customary marriages act that deals with or that regulates customary marriages, and you have the Marriages Act that regulates civil marriages. So apart from those two, you don't have legislation that deals with others. Then we have something that came recently, which is for people who are same-sex people, for instance, right? The civil union.
It's called the civil union.
Yes, civil
Why
union
is it not
act.
just called marriage?
Look, there are a lot of debates around it, right? Because you are entering into a civil union. You're not necessarily entering into a marriage. And when you look at that act the way it is, a lot of people believe that it's the kind of act that is solely meant for people who have the same sex. But when you look at it, it is kind of like gender neutral. You can actually get into a civil union with another person, heterosexual person, right? So it is that, but it was designed to accommodate people of different sexes, to make sure that they have some sort of regulatory framework to formalize their relationships. So it is akin to marriage. There is still a debate as to whether it is marriage. I mean, a lot of people take it as marriage. Like, no, these two people are actually getting married to each other. But when you really zoom into it, there might be questions as to whether it is marriage or not.
What at the current state, what makes it not a marriage?
Look, I think I will be amused to say it's not a marriage, right? Because that's how it's taken as a marriage. But I'm just saying technically, when you're looking at it, it does not appear to be a marriage, because otherwise it could have been accommodated quite nicely into either the Marriages Act or the Recognition of Customary Marriages Act. But they created a separate legislative framework for it to regulate the nuances that comes with it. And it is in that context that I'm saying perhaps maybe the concept of marriage in relation to civil unions, perhaps it might be a little bit contested.
Okay. Can people who are cohabitating get into a civil union?
Yes.
Say it's not a marriage, but we living together even if we not same sex, and I just want to make sure that my rights are protected. I'm not working, you are working, we are cohabitating, we have a relationship.
Look,
I want to make sure
when you look at the structure of the Civil Union Act, it appears as if they can, right? But we don't see that in South Africa.
Or is it?
I think the debate now is how do we regulate cohabitation relationships, and some people call them domestic relationships, some people call them life partnerships. So there is a call to actually regulate that kind of a relationship. Currently, the South African Law Reform Commission is engaged in, it has actually formulated an advisory body that deals with how we can regulate different kinds of relationships in South Africa. How can we formalize them? Okay. Right. And now there is that particular legislative development that is coming as to whether government will or the legislature will actually deal with it and bring it to the fore. It's another thing. Okay. But there is that debate that we need to see how we can regulate all these other relationships apart from marriage. Because they bring rights and obligation. And you find that sometimes people spend so many years in these relationships and they disintegrate or they dissolve through death or some other way, right? And you find that a financially weaker spouse, and in terms of those relationships, they are left vulnerable. Now the question is, how do we then protect them? And find that in practice, financially weaker spouses are generally women, right? So that is the debate that is going on in the private law of South Africa as to how we can actually assist these financially weaker spouses to make sure that whatever relationship that they enter into, they are able to get a better deal out of this marriage. I mean, there are contested views around what a better deal is, right? Because there are people who are saying, but if you get into some type of a union, you know what you are getting yourself into, right? But the reality is that there is this power imbalance from a financial point of view. And a lot of people are saying, given these financial imbalances, there is something that the legislature should do to make sure that those who are financially vulnerable are able to be protected.
The truth is you don't really know when you get into that kind of relationship and you move in with your bag. Overnight bag, and then it grows, right?
Well, that's contested.
You have no idea. No, you don't know. It will keep emerging, right? But the advice right now would be, I mean, I keep saying to people who are cohabitating, it's much better to have an open agreement, a clarity, so that if things fall apart, then you know what's going on. But if you're planning to get married, it makes it easier. But if you're not planning to get married, I just think it's complicated.
Look, I don't think it becomes easier even with marriage. It can even be more complicated. But I think it starts with a conversation. Yeah. Right? It starts with a conversation. Why are you getting married? Yeah. That's the most important part, right? And once you understand why you are getting married, why is the other person getting married? And people don't have those discussions, right? I think the joy and the happiness of these things finally happening becomes a challenge. I mean, when somebody look, I always say to people, like, things like cohabitation, they start in different places where you would not even think they would. Yeah. Look at the university. What is happening at races? You know.
There's cohabitation.
There's a lot of cohabitation going on in residence. You know, there's a lot of cohabitation.
Yeah, I mean, I do remember when I was at varsity, there are people who stayed 4 years with someone, and then they leave, and you meet them 6 years later. You think they're married. No, they last saw each other on campus. It's gone.
That's the thing. But this is how these relationships start. Yeah. And not only in the context of campus. I mean, even in villages, in whatever, people move in together. People do move-ins, right?
Without thinking about it. That's why I'm saying you don't.
But they don't have. No, they think about it.
Is it?
But the thinking is different. Okay. Somebody might be thinking that, look, I want to enter into this kind of relationship for whatever reason, right? But not looking at the broader picture. Yeah. You have your own reasons, but you don't know the reasons of the other person. Yeah. And that's where the difficulty becomes, right? And there might be accusations and counter-accusations. That is not necessary. What is important is it's a conversation. Yeah. Once you have a conversation, it's about, okay, where are we going? In a year's time, where are we going to be? In 2 years' time, in 3 years' time. And those discussions will be, okay, if assets are accumulated during our time, how then are we going to deal with these assets, right? Who has to do what in this kind of... So those are the kind of conversation that will lead to, okay, perhaps maybe we need some sort of an agreement that will be binding between us to make sure that we protect each other. Because sometimes you find that somebody cohabitates with someone, they spend 3 years together. Washes, cleans, and does all these domestic things for this person, and helps this person to be able to accumulate whatever they accumulate. After 4 years, this person gets another person, right? And this one is left. This one is left destitute. So those are the discussions that, and the things we ought not to oversimplify them, because they are very complex, and we need to understand and appreciate their complexities. To say, look, but how do we assist these people, right? Because sometimes, but when you look at family law, the structure of it, there are remedies. there are things that can be assisted. Like, for instance, there is this thing that we call universal partnership, right?
Okay.
It is a company law concept, but it can be used successfully to assist the economically weaker spouse or economically weaker partner in a partnership. To say, look, we have been together for 4 years. I've been doing all these things, helping this person to accumulate whatever. Therefore, I was in a partnership with this person, because had I not done these things, then this person would not have achieved 1, 2, 3, 4, 5. So there are always those kind of things that can be done when you are thinking creatively to assist these people. But at the end of the day, we need regulation. These kinds of relationships, they ought to be regulated so that the consequences can be very clear, so that people can actually be protected, because the state has an obligation to protect people who cannot protect themselves, right? So those are the kind of conversations. I mean, now, like I said, the South African Law Reform Commission advisory board is dealing with those kind of things, and there are different issue papers and discussion papers that have been brought forward, where suggestions have actually been made that we need what they call an omnibus sort of legislation, a single stop legislation that regulates all these kind. I mean, there are all sorts of challenges with that as well, but that's where the discussions are actually at currently.
Now, let's start Gamahadi, Ronar Levatwabans.
Yes.
Two people meet, they have a relationship, 3-4 years later, they decide Babata Mahad. Sometimes they can say, but why low bailey?
Yes.
Or something like that.
As a per se, I mean, it's something quite different, quite different. But nonetheless, you are starting the process of getting married.
Yes. So you start conversations. Maybe some percentage,
yes.
and then you, during that process, are you married? 50% or 60%?
You know, the concept of marriage under custom is quite complicated, right? First and foremost is the Recognition of Customary Marriages Act regulates how one gets married, right? There are requirements that are stated in the Act.
Yes.
There must be consent.
Yes.
You must be of a certain age, 18, right? The marriage must be negotiated or celebrated in accordance with customary law.
Yes.
So you'll find that in those requirements, you don't find the word mahadi, lobola, brideworth, and all those kind of things. So generally, Bukhadi, Mahadi, Lobola is not a requirement for a marriage. The fact
as long as negotiation took place.
As long as there was negotiation.
Yes.
If there was no negotiation, there was celebration. In accordance with customary law.
Okay.
So as long as you can prove that, then you will be said to be. But nonetheless, how do you prove negotiation? Obviously, what is negotiated? That's where then Mahadi comes into the picture. But the fact that there was no payment or payment was in part does not detract from the fact that people are actually married to each other. And that's the issue that we are going through in South Africa. There are people who are married, but they don't know that they are married. And sometimes they even Mahadi has been paid and everything has been paid. And somebody wakes up and one day and says, look, I don't want you anymore. Go. And they can go, no, you have recourse. You know, and the thing is, under those circumstances, then you need to bring in a high court application where the court will actually declare your marriage to be valid. So that you can actually divorce. And when you divorce, then all the consequences of a marriage will then apply.
So and Habari, in accordance with cultural practices, Hari dirle 60% or 50%. Of course, the law doesn't care, but we negotiated, we did that. But mara haisere tlhabisa. Batswana will say
yes.
Because that hasn't taken place. Does it mean we haven't done the whole cultural process and therefore it's not marriage?
We see more and more cases coming up dealing with some of those things, because I was about to say you have those requirements that are in the Act. They are called official requirements. Then we have what we call living customary law, which is uncodified, which is not written, which we rely on the memory of those who so you'll find that they will say, no, these are the processes of marriage, right? They are saying things that are not in the Act. And a lot of people, when those kind of things have not been complied with, they have tried to argue that marriage has not been entered into, right? One of them is the thing that you have said, but in a different way, right? They will say, look, somebody has not yet been delivered to the bride's, to the groom's home.
Yes.
And that then becomes an important requirement that you need to actually go and take the bride to the groom's home to finalize the process. But we have seen the court saying, no, you cannot hide behind that, because in South Africa today, even people at the rural areas, they are no longer steadfast on cultural practices. People are no longer, and again, these practices are different, going from tribe to tribe, area to area. So you can never really say this is how it should be, right? So what happens in the courts currently is courts are more and more relying on official requirements. So if the official requirements have actually been complied with, and you can demonstrate that they have been complied with, then you can actually get your marriage to be declared to be valid.
And that's the negotiation part.
Yes,
The other stuff doesn't.
No, all of them. The age,
Yes,
the
age,
consent, then the negotiation and celebration. Because sometimes you find that people go the whole way. They negotiate. After negotiating immediately, some animal will be slaughtered and people will be dancing the whole night and all those kind of things. That is celebration. So if you can demonstrate that something like that actually took place, and again in these Mahadi things, there are these letters that people are, so you need to just bring those things up, right? If you have that, chances are the court will be more inclined in validating the marriage as opposed to invalidating it.
And why then do they then already say that's community of practice? Community of what?
Of property.
Of property.
Because in order for you to be married, it is a default marriage system, right? So when you get married, automatically you are married in community of property.
Okay.
So if you don't want community of property to be applicable to your marriage, then you need to make sure that you sign and conclude an anti-nuptial contract.
So where do I sign that?
No, you need to do all these things before even Mahadi even before you think about approaching parents. If the two of you are thinking of getting married, that's where you start. You start with an anti-nuptial contract if you don't want community of property to be applicable to your marriage. So if you do not sign that contract, then the marriage will be automatically.
And we can sign that contract 3 years before we get married.
You can sign it whenever.
Whenever.
We can
as
sign
long
it
as today and get married.
It must be pre.
Yeah, it must be.
It must be before marriage.
Is it?
Yes.
Okay, so if we did Mahadiana celebrate le Haraira antinuptially, ke community of property. Le gare ka ngwala mo pampiring eo e re agreeang ka yona ke re ba ngwala gore o ntshitse bokae what borakgadi, and then be ba bua gore be lona le babedi re ga re batle go motlhakanelwa ka signa le motho a ka signa re ga re batle motlhakanelwa.
Look,
still re santse le motlhakanelwa la re sign
it will be community of property. But there is a nuance to it, because remember, an anti-nuptial contract must be executed by a special attorney, a notary public. It must be done at the deeds registry.
Okay.
So it's a formal process. You don't just sign it between yourself. It must be notarized and all those kind of things. So it's a formal process that must be that must go through the processes. But what you are raising is quite intrigued. Recently, I received a request. I won't mention names because all these people you know them. To advise on the issue that you are raising, where somebody was saying, but the parties intended not to get married in community of property, but they did not conclude the anti-nuptial contract. So now the question is, how should the court deal with that? Because a contract is the meeting of the minds, right? People have thought about something. It's just that they did not actually go all the way to do it. There are cases from back in the apartheid days, 1950s, where one of them specifically says, if the parties intended to get married out of community of property and they can actually prove it, they have an arguable case to argue it. As to whether it will be successful in this day and age, I'm not really sure, but it's something that you can argue. But to be on the safe side, before you get married, before you start all these cultural things, you need to make sure that you sign an anti-nuptial contract.
And many people do it after Mahadi. Badira Mahadi, be basana anti-nuptial, be baira lenyalo, basana kwamukli.
Yes, that will create.
They should do it the other way
yes,
around.
that will create a problem if any one of them wants to get out of that contract, because they can say we got married and we signed this thing after the marriage, and therefore this is not an anti-nuptial contract. Yeah, so it can raise all sorts of arguments.
Obviously, the one who changes their mind later.
Exactly. Unless the parties somehow they were able to later get married into civil marriage, right? They were able to get that, and that thing was done. But again, it will be like, okay, what was the first marriage? and what were the nuances between those two marriages. Because you cannot be married in two marriages at the same time. When you can be married under customary marriage, right? And then you can later change on and get married under civil marriage. There's nothing wrong with that, right? Yeah. But then it will create all sorts of challenges as to how do we then, or what do we make of this anti-nuptial contract? How do we actually deal with it? It can be litigation for days.
Wow. Okay. And then people now are married in community of property, either through customary or through civil marriage. When they part, I was shocked to know that actually the other person is entitled to 50% of your pension funds.
Yes. It's not 50% per se. And I think perhaps the percentages are done for convenience and practical purposes, right? Especially when people cannot agree on the division. What normally happens is when you get married to someone in community of property, you are actually agreeing to be a co-owner of everything that was acquired before the marriage and everything that was acquired during the marriage in undivided shares. In other words, whatever you acquire that has monetary value, apart from the non-patrimonial assets, like for instance, when you have delictual claims against somebody and you are able to get rough money or something like that, that will fall into your non-patrimonial benefits, so they won't fall into the marriage, right? But all the patrimonial benefits, your house, your car, all these kind of things, they will form what we call a joint estate. And in the joint estate, you are undivided co-owners. You are co-owners in undivided shares. In other words, you own that thing 100% each, right? But when you get divorced, for practical purposes, they will say 50-50. Because you cannot divide 100 by 100. It doesn't. You are a mathematics person, you know, right? Yes. So for practical purposes, they will say, look, you cannot agree, therefore split it in half. But it doesn't work like that. It's possible that it can be 99-1.
Is it?
It's possible that it can be 10-90, right? Because divorces sometimes, or most of the times, they are a process of negotiation. Sometimes what we do, we look at the value of the pension interest, right? How much the person is likely to get if they were to exit the fund at that time. And we look at the other asset that they have. Let's say maybe the pension fund is 3 million, right? And you have a house of 5 million, right? It might not necessarily, if you are negotiating, it's possible that you can say, look, I don't want you to get anything out of this house. I want to keep the house. Perhaps I will give you 80% of the pension interest. You understand? So it will be that negotiation that going. So it's not there's no law that says you need to get 50%. It's just that practically, that's what people go for.
All right.
But indeed, I mean, when you look at the assets, pension interest definitely, it does not necessarily fall into the joint estate. What the Divorce Act does, it says it is deemed to be an asset for the purposes of divorce. So ordinarily, it's not an asset in the marriage. But when you divorce, then it is regarded as an asset, and then all those calculations will be made for the non-member spouse to be able to get a share, and a share will be determined by agreement, or the court might order what is equitable under the circumstances. And normally they settle for 50-50.
Okay, and then tell me, I think there's something called alimony. Is it alimony?
Alimony is maintenance.
Maintenance, but for the other spouse. Usually,
yes.
I mean,
what normally happens is when two people get married to each other, what we call a duty of support is created, right? Irrespective of whether you are married out of community of property or in community of property, marriage, the contract of marriage or the concept of marriage comes with it duty of support. Because you might be married out of community of property, but you are still living together, right? And you are still, in a way, supporting each other. And depending on the circumstances, you are going to bring money, somebody will do something, there will be duties and responsibilities. So that duty of support, it is in that context that when you part ways, we are saying, look, now that this duty of support is terminated by virtue of marriage, then it's important that the other party is able to assist the other one, perhaps up until they remarry or they become self-sufficient, or even for a lifetime. Now, the concept that is becoming more and more popular in South Africa today is what we call rehabilitative maintenance, right? This is where somebody will say, okay, we look at the age of a person and say, no, this person maybe in 10 years' time or in 3 years' time, 5 years' time, he or she mostly might be, and I'm not disrespecting women because the women are making strides, right? This is not out of disrespect for women. I'm just saying, in practice, majority are women. She might be able to be capacitated, assisted, might go to work and whatever. If that is the case, then the court will say, no, let's give you 5 years. This person must give you maintenance for 5 years. After 5 years, you should be in a position whereby you can actually maintain yourself. Normally, that's what it happens. But there are certain judges and magistrates who are willing to give lifetime maintenance.
And does that happen only if there's inequality in terms of worth?
Yes.
Even though you
not
can
worth personally, not worth as a personal worth in terms of assets, yes, finances.
Yeah, finances. Even if the partner might be able to take care of themselves, but asset-wise, I am much more well endowed than them, they can claim duty of care and then say, no, I won't be able to stand on my own, even though ba bereka and they get...
There should be a need for maintenance.
Oh, okay.
South Africa is unlike USA, right? It's not that glamorized. Yes. There must be a need for maintenance, and there must be capacity to pay maintenance from the other side, right? Yeah. The fact that you are paid 50,000 and the other person is paid 100,000 doesn't mean that you need maintenance. Right? The court will have to zoom into the circumstances of the parties and say, is there a need for maintenance under these circumstances? If there's a need, then obviously issues like child maintenance will be taken into account and all those kind of things. There must be a need. And if there's a need, there must be capacity to be able to meet that need. And if that is the case, then the court will exercise its discretion and say, we are ordering one to pay the other. And again, this maintenance is not an exclusive right for women, right?
Yes, it's for men.
Men can actually ask for maintenance. I mean, in my practice, I see a lot of men's ego making it difficult for them to ask for maintenance. But men can actually ask for, it's gender neutral. It's not a right for women.
Well, these days they do ask.
It is a right for financially weaker spouses.
True.
Most of which in practice are women, but you can find men as well.
So you are saying duty of care when you are in
duty of support.
Duty of support,
yes,
when you are in a marriage union. So if you are married out of community of property without accrual, and you then divorce, this idea of duty of whatever
of support, yes,
does it come into play? How does it come into play? And you are unemployed.
Look, duty of support.
Still have to do that.
Duty of support arises by virtue of marriage. It doesn't matter whether you are married in community of property, out of community of property.
So I might have to support you.
Yes.
Even though you are married out of community of property.
Even though you are married out of community of property or you are married with an accrual system, it doesn't matter.
Wow.
Duty of support arises by virtue of marriage. If you are married to someone, marriage itself says,
wow,
I am going to be with this person forever. We are going to be the life and rights, and we are going to do all these things that we do together. So if at the time of dissolution of marriage, it so appears that one of the parties is financially vulnerable and they need support, they can easily claim support from the other party. And again, perhaps let me explain this concept of accrual. Accrual is simply, I mean, in layman's terms, it is contested, but in layman's terms, it's just marriage in community of property delayed.
Yes, yes, because after marriage, whatever you accumulate, I agree.
So, because with it, it's in the antinuptial contract. By the way, if you sign an antinuptial contract and you don't specifically exclude the accrual will be applicable.
Oh,
you don't have to say with accrual.
But normally the lawyer asks you with or without.
Yes,
a smart lawyer will ask you, and then will.
Well, it depends. A lot of people who are practicing in family law, they are trying to assist as much as they can. So in most instances, they will try to get the parties to go the accrual route.
Is it?
Right. They will try to do that. I mean, there are all sorts of challenges with these kind of money. But nonetheless, an accrual is just to say, look, everything that I had before we got married,
it's mine.
It's mine. I want to specifically exclude it out. Yes. Right. Everything that I will be able to accumulate during the marriage, and it during the marriage, and it grows. Like accrual in the context of family law, it's growth. It's just synonym for growth, right? Anything that grows, then at the end of the marriage, that thing should be taken into account. And if there is any spouse between the two whose accrual or growth is lesser than the other, then the two must be combined and divided into two, and then they can share. Basically,
if you don't want to do that, perhaps you can open a trust together.
No. If you don't want to do that, you want in the anti-mutual contract, you just
without accrual.
You just need to specifically say without an accrual.
Yeah, but we are getting married, so we can say, okay, we can. I'm just thinking you can say, okay, we open a trust, we put the money in the trust and everything, the properties that we want our children to have, or we want to own together.
Yes, I mean, a trust is a different financial vehicle. Anyone can. You and I can open a trust.
Yes,
right?
Yes,
the two of us.
Yeah.
We may be living different. We have never personally met before, right?
Yes.
After this, we can say, no, let's open a trust. For whatever reason.
So I hear you. I'm just saying, if I were to advise someone, I would say, look, do anti-nuptial without accrual, open a trust.
But the question would be, why do you want to
have...
I think the question would be, why do you want to open a trust? Because it is important, whatever financial route that you are taking, there must be a purpose behind it. Because a trust comes with its own baggage, right? Okay. Because one, if you're going to open a trust, because you're going to put assets, house, whatever, perhaps it makes sense.
Yeah.
But if you're going to open a trust that generates money, the tax component of a trust is ridiculous. So you need to really get financial advice as to how the trust actually operates and why do you want to open a trust. Are you in business? What do you want to do? Do you want to leave something for your children? So those are the components that you need to really look at.
But Mutsuti, let's see it this way. So the first thing is, why do you want anti-nuptial? We are both professionals. We want to start businesses. We don't want whatever happens financially when I have a business, blah, blah, ends up affecting you and we all go down.
Yes.
So that's why we want anti-nuptial and we want it without accrual. Because if we have it with accrual and I start my own business and it goes topsy-turvy and I owe millions, you will be affected as well. So now we start a trust, we can have a house, we can buy a house in the name of the trust. Then we know if my business goes underwater, one of us is financially secure, we can continue living in the house belongs to the trust. In a way, you can't just kick me out of the house, I'm covered. If it happens, do you see what I mean? So in a way, we are sort of fine in the house, and now I can find my way because my business went under. Doesn't that make sense?
Look, it depends. It depends. By the way, in terms of the protection that you're talking about,
yes,
getting married out of committed property, you will have that protection. You don't need an accrual.
Oh.
It doesn't really matter whether it's an accrual or whatever. Out of committed property, you'll have that.
Oh, okay.
If your partner gets, or your husband or your wife gets sequestrated, for instance, and you are married out of committed property, the trustees, they cannot go after the solvent spouse, right? So you are out of committed property protects you.
But then with accrual means that I still own that debt.
No, not really, because accrual depends on the growth, right? It's a promise. It's not something that.
But negative growth is growth.
It might happen, it might not happen, right?
Okay.
It depends on the growth. It might be that at the time of marriage, your accruals are the same.
Yeah.
And if they are the same, no one will benefit from anyone, right? So if the issue is protecting assets from creditors, the best way of doing it is just to get out of committed property. Okay. And I will never advise anyone to get married with an accrual also, because like I said, it is a delayed committed property, right? It really doesn't make sense. But anyway, there are people who do it. But when it comes to a trust is different.
But vehicle, how would you advise people then?
Look, I always tell my clients that, look, you need to look at the structure of a trust. What is a trust? To understand what is a trust. A sui generis sort of legal instrument, right? Which a grantor creates to benefit someone, right? And that person will be maybe the children and whoever. Now the question would be, a lot of people create trust because they are in business. And you find that some of the trusts, they own these businesses and the businesses actually put money into the trust. But there is a hefty tax bill in relation to trust. So you need to understand what it is that you want to do with the trust. If it's an issue of, look, we are opening a trust, we want the trust to to buy a house to, we are going to donate a house to a trust or something like that. We want the trust.
Can the trust buy our cars, our house?
Exactly. We want the trust to own these things, not us.
Not us.
But remember, when the trust owns something, it must be for the benefit of someone. Right? There must be beneficiaries. Okay. So the beneficiaries must be well defined. These are the beneficiaries who are going to benefit. What we see more nowadays is like people use trust in their personal things, right? You open a trust, you buy things, and it benefits you as either the grantor, and the grantor also becomes the trustee. And you find that is the one who's mismanaging everything and all those kind of things. So you really need to get sound advice on especially the tax implications of a trust. A trust is not a beautiful sort of instrument as most people think. It is wonderful if it is used for the right purposes and you know exactly what you are doing with it. Right? It's not something that you just wake up and say, now I'm opening a trust because I want my house to be owned by the trust. Right? You need to have a clear sort of idea as to what you want to achieve with it.
I see we're running out of time, and I have one more question though. If you were to advise two people who are getting married out of community of property, anti-nuptial contract. Take an anti-nuptial contract, they are starting life, it's their first marriage, they don't have children, and you are saying to them, without accrual, how do they manage all of this? I mean, you see, I was thinking trust, because I'm thinking there's at least something you should own together.
There are different ways of owning things together. You can buy a property together. And it can be both in your names. True. Right. You can sign a joint contract. There are different ways.
So of you don't necessarily need it.
You can have a joint. You can have a joint account together. Say, look, majority of the money comes here. All of us have. There are various ways of doing things to make sure that. Look, I think marriage in community of property is a bad deal. Right. It's a bad deal. Normally, what happens is there are two ways of looking at it.
Bad deal.
There are two ways of looking at it. The person who is financially well at the time will push for it, right? The person who is financially not that well will push for community of property, right? And there will be an issue. My point exactly. Yeah. Especially when you are married and you are young. Yeah. You invest on yourself and the partner invests in you. Life today is not going to be life tomorrow. And again, when you get married, one will think, at least people our age, you get married to somebody who, even though they are not well today, they have the capacity to be well, right? Yes. And if you get married to such a person, you don't get married based on the assets as they seem now, because you get married because you want to accumulate. And it might be that in 5 years' time, the one who was here will be there, right? So I always say, and you raise an important thing, that when somebody goes down, should not drag the other one. The other one should be able to pull them out, right? So marriage is in community of property for me, it's a no-no. The accrual also for me, it's a no-no. I think people, when they want to get married, can get married out of community of property, then invest in each other, right? Where you don't have a spectator and a star. A lot of marriages are comprised of spectators and stars, and that becomes a problem. Stay at home, I will be out there. That becomes a problem. In this day and age, young people should not settle for that. You go, I go. Right? You don't want to come here, somebody's complaining about the lights and all those things. I want to hear what is troubling you here at work or in your business. Those are the kind of conversations that we want to have, right? And when we start getting into those kinds of relationships, we are talking growth. We are talking advancement, progression. And that assets become less and less important. Our relationship becomes even more, we are able to bond even more, because we are no longer concerned about, hey, if I get married, if I get divorced, what will happen? You know, you get worried about, how can I better love this person? How can I better improve this person? And how can we invest in each other? So I think the concept of marriage has changed with time, right? From the days when one person was supporting the other or was the breadwinner, to the day whereby if you are in this concept, you can actually go forward. The other one can invest in you, and you can grow, you become even better as people. So for me, marriages out of community of property, they are definitely, marriages in community of property are definitely, I will never advise anyone to get married in community of property. It doesn't make sense, at least for me.
Mutsutsile, thank you so much. I have learned so much. I thought I knew, but I've learned so much in this session, and I hope you all at home have learned as well. I mean, just in brief, to show that I listened, right? Professor Mutsiutsile, Marumoagae, says marriage in community of property is a no-no. And if you do antenuptial contract with accrual, it is just delayed in community of property. No as well, according to him. And he advises antenuptial contract. Don't worry about opening a trust. You can do things jointly. And, you know, a successful marriage should get to a point where you don't talk about assets, you talk about growing your partnership together. I like that what you said about, you said a union of support. What did you call it?
Duty of support.
Duty of support. But both sides, not from one side. So I hope you learned a lot. I hope you remember all of that when you decide to cohabitate, to marry someone. It's good to have this knowledge with you. But thank you so much for joining us. Remember to subscribe, press notifications, like, share, and tell your friends and your family to join us too. And here's the thing, be yourself. It's only when you're yourself that you can do yourself. See you tomorrow.